All right. Great. Welcome to Judiciary. We have 3 bills in front of us today. And I think we have the committee that we're going to have for the day. So let's go ahead and call roll.
Senator Kriegel,
Aye, or here, sorry.
Senator Crum,
Excused?
Senator Hicks,
Excused?
Senator Kolb,
Present.
Chairman Olson.
Here.
You have a quorum.
All right. I might mix up the order a little bit here. Let me ask, who is here for Senate File 58? Raise your hand if you're here for Senate File 58. Okay. Well, we're going to do Senate File 58 first. So first bill we have Senate File for our consideration committee is Senate File 58, the Wyoming Indian Child Welfare Act sunset repeal. This bill repeals the sunset. Yes, come on up. Welcome to Judiciary.
Thank you, Chairman Olson. Judiciary Committee, my name is James Charles. I'm the tribal liaison to the Eastern Shoshone Tribe at Governor Gordon's office. And I would just like to say briefly that the governor does support this bill as a repeal. And normally we do not speak for the tribe. However, I have spoken to the chairman, Waylon Large, Vice Chairman Stanford Ware of the Eastern Shoshone Tribe, and they also are in full support of this bill. And with that, I stand for any questions.
Fantastic. Thank you. Any questions, committee? All right.
Chairman Olson, members of the committee, my name is Anita Roman. I'm the liaison to the Northern Arapaho Tribe out of Governor Mark Gordon's office. Again, Governor Gordon does support just removing the sunset date of this bill, so there's not much more to there's no changes. I also spoke with the Northern Arapaho Tribe just this morning, and they would have loved to testify. It was a lot of conflict surrounding their schedule with six council members, so they just asked that I get up here and just reiterate that they testified at committee on our select committee on tribal affairs this most past month, and are in support of also just the repealing of the sunset date.
Great. We really appreciate you coming to the committee and giving us some insight into how this bill is supported. That's really helpful. And just appreciate your testimony. Thank you. Is there any other public testimony on Senate File 58? All right, I will close public testimony. Committee, what is your pleasure?
Move the bill.
It's been moved by Senator Kolb and seconded by Senator Kriegel. Any discussion or amendments on this bill? All right. Question being called. Here, do a roll call vote on Senate File 58.
Senator Kriegel,
Aye.
Senator Crum,
Senator Crum left no vote.
a no vote.
No, sorry. That's confusing. Senator Crum did not leave a vote.
Okay.
So I'll just say excused.
Senator Hicks,
Do you have a vote sheet?
I do not.
Okay, excused.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
3 ayes, 2 excused. Do pass.
All right. We'll make sure Senator Hicks floor manages that bill. All right. Next bill for our consideration is Senate File 45, local approval for simulcasting. And I believe Senator Kolb, you're going to
You want me to?
first introduce this bill.
Should I do it here, Chairman?
Wherever you're comfortable. You can just stay here if you'd
Oh,
like.
That's fine. I can let other folks sit up.
Yeah, well, that's fine.
Thank you, Chairman Olson. This bill is approval for local simulcasting and went through our committee in the interim and sponsored through Management Council. We worked all summer on this for a little bit of background for people that maybe are listening about this for the first time. And the bill's purpose is to actually get local control within a municipality and a county for approval or disapproval of the simulcasting activities, which currently is an issue. The way it's currently working, the thought is through the Gaming Commission and the process of municipalities and combination with the counties, they basically have to approve if they've already previously approved in the county and have these activities. And there's no mechanism it's felt at this point that they can deny. And this bill is the result of collaboration between the industry, local, county, and city officials on trying to craft something that is a path forward to improve what we're currently doing. The bill it's a fairly extensive bill in that it's dealing with a lot of issues that have not been addressed yet. We haven't had legislation, I think, this mature to even talk about. So the bill in front of us does just that. Primarily, it gives certain rights. It deals with currently issued licenses because we're trying to basically, as the joke goes, fix an airplane as we're flying it. And that's the challenge. We have to get a path forward that unwinds what we currently are doing to be fair with the people that currently have licenses issued. And then figure out what we can do next that gives the local authorities the ability to say, no, our community doesn't want this activity anymore where it currently is. It gives them a voice that currently they don't have. And then there's a lot of already decisions made through the court that's caused this to be an issue, a proven issue. So I just want to say to the people listening, this has been a collaborative effort between lots of people, House and Senate and industry. And I see we have a lot of those people here today, and I'm sure they'll have something to say about this. I hope they will, about what they think about this bill, and hopefully we'll be supportive of it like we were during the interim. And I don't know if I want to go through this page by page, Mr. Chairman. I'd be happy to, but in the broad scope of things, that's what this bill does. And there's a lot of parts and pieces to this thing about why it does what it does, because unfortunately, it's not a single topic when it comes to how we do this. Things have, frankly, in my opinion, spun out of control for years. And this is a mechanism to be fair to everybody, to be fair to the municipalities, to the people of the state of Wyoming, to deal with the businesses that are in our community, and have a path forward. I'll leave it up to you, Mr. Chairman, how you want to do this. We can take it page by page, or I can start explaining the sections. What would you prefer, Mr. Chairman?
Senator Kolb, you don't have to necessarily go just page by page, but this is new for our committee, meaning me, because the two of you obviously have seen this bill before. But if you don't mind just explaining the sections, I think that would be helpful for the public who's listening, so they have some explanation of this bill.
Well, let's start off with the first section. Section 1, simulcasting permits, rulemaking, local approval, and permit conditions, revocation, and judicial review. And it goes through a process that's laid out. There's a lot of existing law here. And then the changes, of course, have been highlighted. Let's see. Guess I should have marked this up, Mr. Chairman, in that method, so I'm kind of winging it. The 100, I guess, is a highlight. Currently in this bill, the simulcasting 100-mile rule is still in effect. That situation has evolved to the point where it becomes really not an issue anymore, because the way the different business owners have cooperated together. It was a big deal back, frankly, when I was a county commissioner. It was to keep horse racing alive. But since then, just for the educational purposes, the historical horse racing machines pay a percentage of the purse for live horse racing. And there's a connection there. And that was the original purpose of that gaming activity, was to promote live horse racing. So the reason for the 100-mile rule kind of goes away because there's collaboration, cooperation between different operations. And that's why it's currently in here. It was thought that it doesn't do any damage and we'll keep it in as is. Next, I guess the revocation of the, let's see here, the approval authority. It sets out a clear path for the approval authority between counties and cities. Simply put, if the operation is held within a county, the county has the ultimate ability to approve or deny said request. And if it's within a city within that same county, the city has the ultimate authority. However, they have to take comments from the county and vice versa with the county to the city. So there's a cooperative agreement because of the nature of gaming, law enforcement, and the reality of doing it. You're not an isolated group. So there's a mechanism, and that was agreed to by WHAM and WCCA, that this was a mechanism that they wanted to employ, and we had agreement. So I guess I'm going by the last thing I had heard about agreement, and that's where we left it, that we were good through the interim. The revocation and the situation is what do you do with existing licenses? Well, you have to let that permittee time run its course. If they have a license issued for 3 years, you would review after 3 years. You can't then review that license before that time after this, if these rules, this statute becomes law. And that was an important part of this. That's a legality issue. But however, there's a process for people that are going to renew, and there's a process for people that are going to request a new permit. They're slightly different paths. And I will say there's a few amendments I'm going to propose after I try to explain the bill and have everyone's, of course, chance to give their opinion about those. It gives the clear ability to consider the welfare of the community instead of just, I guess approval because it's already been pre-approved or other things have been approved for licensing. It gives the community a chance to weigh in, and the local elected officials, be it city or county, have a chance to review the application and then make a value judgment when they get input from the constituents. That's some of the complexity here. We have a current situation where people feel like they have no voice, and I tend to agree with them. They don't have a voice. This will give them a local voice, and then it'll be up to our local leaders and elected officials to have a path that works with their community. Every community is different in the state of Wyoming. We have lots of different situations, even within a county. And this allows that to happen. That was the desire and the goal here. I will tell you, no legislation is perfect, but this clearly is a path forward that gets us where we want to be. And it's the first change that is in front of us in the Senate that accomplishes this. A similar bill to this came through the House last year, to give you a bit of a history. It wasn't this same exact bill, but a lot of it still exists. And the intent of that original bill is still within here. We had worked it as a directive from Senate leadership to improve it, have conversations and agreement and buy-in. And that's what this bill accomplishes. Now I'll let maybe my more legal scholar type folks, the attorneys, maybe comment. If Senator Crago wanted to have a comment about that. Senator Crago and I served on this task force over the interim, and we work with the House members to get where we are. It was a process, but we have a product, and I feel it's a good product. And once again, I wish we could hear from everybody who had input during this interim. But Mr. Chairman, could we have? Would it be all right if I give Senator Crago? I don't want to put any words in his mouth, but if you want to comment, Senator Crago.
Do you have any comments at this time, Senator Crago?
No, Mr. Chair.
You're doing wonderful, Senator Kolb.
Well, I'm fumbling around with 2 hours of sleep, so you have to excuse me. I'm probably not on my best day, but I think I would Mr. Chairman, I would obviously stand for questions when they come up. And I think that would be, at this point in time, I think I'd like to just move it to the next step after the bill explanation. I don't know if I did a great job. There's no fiscal impact, just to point that out in the fiscal notes. This is mostly just a revamping of the ability to game within the state of Wyoming. It's the first attempt to really get this into public view and have a public choice. I'll leave it at that.
Okay. All right. Thank you, Senator Culp, for that explanation of the bill. Let's go ahead. We're going to start moving through the public to comment on this bill. I know we have some amendments, but I'm going to take all of the public comment first, and
Yes.
then we'll talk about some possible amendments. Start with the Gaming Commission. Oh, and then the governor's office as well. Sarah, you have no comment? Okay.
Thank you, Chairman Olson, Senators. My name is Nick Laramendi. I'm the Executive Director of the Wyoming Gaming Commission. I'm not here to speak for or against any legislation. I will tell you, as this bill is drafted now, this wouldn't be problematic for the commission to implement new processes. Currently, just to clarify, simulcasting can only be conducted off the permitted premises, which would be the racetrack, if the Board of County Commissioners approves it. So what we've run into, currently we have 43 off-track wagering locations across the state. All 43 of those have been approved by the county commission. 42 of those 43 are within municipal boundaries. So the city council, the mayor's office, those kind of things, they have no input in that. So our office has fielded calls from, local elected people wanting to know how this new location popped up, on Main Street in their town. And that's because the county, gave their approval and the city didn't have to. With that being said, I would like to draw your attention to just a couple of things in the bill. Maybe on page 8, line 17, this is about the revocation of it. It says notification from the commission that a permit holder has acted in violation of any Wyoming gaming law. I think it might be cleaner and easier if it says if the permit holder has been found in violation. That way it's not an allegation, it's a full hearing and they've been found to be in violation, either of administrative violation or in those criminal codes as well. And then the last thing that I would point out, and I don't know if this is, if the date thing makes a huge difference. These permits by the commission are granted on calendar years. So from January 1 through December 31st. On page 13, starting at line 12, it says that they will be authorized to continue operations through June 30th. That would actually be 6 months into a permit if it was a 1-year permit, because that permit would expire at December 31st. So I don't know if that would make a difference to you all, or if that would be cleaner if it was just changed to December 31st of 2027. And I would stand for any questions.
Great, thank you. Thank you for pointing out those potential changes for us. That is helpful. Go ahead, Senator Cole.
Yeah, thank you, Mr. Chairman. Well, thanks for the epiphany, Nick. Thank you for that. But I think for the edification of people that may not understand how this works, that I don't want to put words in your mouth. So if I say something wrong, please correct it. When we have statutes that we approve, governor signs, the Gaming Commission then promulgates rules. And so they cannot do anything beyond the statutory authority they're giving to promulgate rules. So when it comes to issues for the Gaming Commission that they find, they're powerless because the statutory authority in these cases doesn't exist. So this bill is going to give you more authority to input local control and your board more authority. I mean, That was the conception of part of this bill, was to make our gaming commission more effective. I mean, they're good people trying to do as much as they can, but they're trapped. They're trapped within the rules. We can't tell them what to do. There's no connection between us and the gaming commission because it's formed by the governor. But we can promulgate, we can change statutes, and that's what this does. So in whole, Nick, do you feel like this makes you a more effective commission in the ability to deal with those local questions that you have, you know, through the city saying, hey, how'd this happen? Well, just an opinion about that on the effectiveness of you being able to do your job in your gaming commission.
Thank you, Chairman Olson. Senator Cole, I think you're exactly right. You know, we've actually fielded a lot of calls from municipalities and requests to modify our rules to input something about local control, but without the express statutory authority, this falls outside of the purview, and our commission can't do anything but follow what the current law is, which is the county. So this would definitely help the commission, you know, be able to talk to the most affected parties. Like I said, you know, we currently have 43 OTBs. 42 of those 43 are in municipal limits. There's only one that's in the county that the county deals with completely. The other 42 are all in city limits or municipal limits. So the affected party, the municipality, really doesn't have a say. And there's not a lot that the commission can do to solicit anything from them. So I think this definitely would help the commission kind of weed these out and work with, you know, the respective elected officials, whether it be city or county, to clean this up.
Further questions? No? All right, we appreciate it. Thank you. Any other agencies wishing to testify on this bill? If not, I'll go ahead and move to WHAM and the county commissioners. If you want to testify, now is your chance. Welcome.
Mr. Chairman, members of the committee, I'll just do a brief opener. As my counterpart here, Mr. Ryman really has the guts of where we're trying to get to. So just as a review,
Hey, Ashley.
my name is Ashley Harpstreet with Wyoming Association of Municipalities. But we are super excited about this bill. We appreciate the opportunity to be in consensus with the Gaming Commission, county commissioners, and permittees. We would like to be business-friendly partners as this industry is becoming a big part of our local communities. Like the director just said, 42 of the active 43 permittees are within municipal borders. Mr. Chairman and committee, I cannot stress how important it is for local authority of the governing body to be at the table as this industry moves to our main streets. Any legislation that will allow the local governing body to have a seat at the table and allows for a new notification process that allows for local input will be critical, as it provides an opportunity for the citizens to define what their local landscapes look like. Cities and towns across Wyoming have different cultural attitudes towards gambling. Local control allows each community to decide whether HHR aligns with its values and priorities. We are happy about any legislation that aims to clarify and balance authority between cities and counties, reducing the risk of legal disputes and fostering cooperation will be beneficial for all those involved. Additionally, taking action now is about protecting the future. Currently, all activities are 100% served by municipal law enforcement, fire, street maintenance, and other public services. While it is under control at this time, depending on the growth, this could change the scope of service and strain on municipal services provided. I want to make it clear that the current permittees that are in place, we are working very well with. Zoning alone cannot control social and welfare issues that we deal with in this industry. For example, we need legislation to allow local governments the ability to impose specific conditions on permits, such as hours of operation or location restrictions based on their unique needs and concerns. Thank you for this time and the deep dive into this very important matter. Today, I'm joined with my counterpart from WCCA, Mr. Jeremiah Bryman.
Thank you, Ms. Harpstreet. Mr. Ryman, you have something that you want us to know?
Sure. Thank you, Mr. Chairman, members of the committee. I'm Jeremiah Riemann. I'm here on behalf of the Wyoming County Commissioners Association and really appreciate you taking up this legislation. It is something that we've been working on for a couple of years and strongly support you moving forward with. I'll just start with the why. Why do we need this legislation? Well, we've run into some issues, and you heard from the director that the Board of County Commissioners is the entity that you are required to receive approval from in order to move forward. And that's about all it says in state statute. And in fact, we now have Supreme Court decision that says once we grant approval, we have no additional authority over that activity that resides with the Gaming Commission. Now, some counties have tried to enforce parameters and force the operators to come back at some regular interval through some sort of agreement, which is great. There are agreements in place with all of the operators in the state of Wyoming right now. The one lingering question is, do those have enough force and effect given what the current state statutes say and what the Supreme Court has said? So we have tried to work very collaboratively with everyone to come up with the legislation that's before you. That said, there are a few things that are at issue, and so I've provided you with a document, and we've been working, Ashley and I, collaboratively with all four of the operators in the state to address issues. And I'd like to go through each of those, if that's okay, and point out what we've come up with and perhaps where we haven't reached agreement on things.
Yes, that would be helpful.
So, Mr. Chairman, starting with the first issue on the document that you have, off the permitted premises. If you go into existing statute, it indicates that simulcasting may be conducted off the permitted premises only if the Board of County Commissioners grants its approval. And I've kind of paraphrased a little bit there. And so we've had conversation about inserting those words off the permitted premises into the language. And so that's the first proposal. That is one that we have agreement on to bring to you. There is still disagreement on issue 2 that shows up there, and that is the 100-mile rule. And I don't know that we're going to get to a conclusion on that, and so I'm not bringing you any specific language to that. But I want to highlight to you that that still remains a point of contention amongst all of the parties. Mr. Chairman, moving to the third issue, which I've titled "or renewal." If you go into page 7, line 2, it has the provision that we can grant our approval, or we may impose reasonable conditions on approval. We're just simply asking to insert the words "or renewal." That is a place where we have agreement on it. The next one is on page 9, line 7, and that is to delete the word jurisdiction and insert vicinity. Again, another place where we have an agreement on, and frankly, this is something that we brought forward in the conversation, because if you go into liquor license law, which this provision is modeled after, it uses the word vicinity, and that has some case law available and associated with it. Jurisdiction is a little bit more unclear about what that means. So we would suggest going towards vicinity for that particular one.
So Jeremiah, on page 9, this section that you're amending, I have no problem with that amendment, but I actually have I take some issue with the language in this paragraph in general. I'm a little confused by it from a legal standpoint, that you must either be adversely or seriously affected. I can understand showing what adversely means. That is intuitive to me, but I'm not sure how you would show that you were seriously affected, or what that would even, how you would judge whether you've achieved seriously or not. Do you have can you give me some idea of why this language is here, or do you have any idea of why this language is here?
Yeah, Mr. Chairman, I don't know that I can unwind the underlying question that you have, but that language comes directly out of the liquor license statute. So if you go into 12.4.104B, Romanet 2, or sorry, Romanet 1, it specifically says the welfare of the people residing in the vicinity of the proposed issue or proposed license or permit premises shall be adversely or seriously affected. So it's a duplication of current statute relative to liquor license law.
Okay. Doesn't help me understand it, but at least I know where it came from.
I'll let the legal minds work through that, but that is exactly where it comes from. Mr.
Thank
Chairman.
you.
Mr. Chairman, the next one relates to judicial stays. So if you go to stay on page 9, line 13, and running through 14, or actually through 16, there's a provision in there that says during the pendency of the appeal, that the simulcasting shall remain in full force and effect. There was some question amongst all of us of what happens when it is a legitimate case and we should be closing that location down. Would a judge be able to do that when you've got such direct language here? So ultimately, the group agreed, all the operators and us, that we would just remove that provision and leave it to the discretion of the court. Mr. Chairman, the next one is related to right of appeal. And I want to be very clear. My interest in this is right of appeal on initial applications. Have no issue with the right of appeal relative to renewals. The right of appeal on initial application shows up on page 10 in the bottom portion of the, or actually, let's see, is it paged? Yeah, it's actually at the bottom of page 9, starting on line 18 and moves over to page 10. So this is one where we do not have agreement amongst the group of what to do, but it remains a very important issue for my members, and I'll come back to that one here in just a second. Mr. Chairman, 2 final issues that show up on page 2 of the document that you have. The first one is on page 10, lines 5 through 9. The language that is inserted in those lines on page 10 doesn't reflect the agreement that we had with some of the operators relative to change of location. And so we've worked together collaboratively to come up with the language that is proposed there. And again, this is a collaborative amendment that we bring forward. Essentially what it says is that if an operator, and I'll just use Cheyenne because it's easy for me, is on Del Range and wants to move to downtown Cheyenne, and the city of Cheyenne says that that's an acceptable thing, then it would be considered a renewal when it came back up. If they wanted to move from Del Range out into the unincorporated part of the county, that would first not be allowed, and it would become a new permit to proceed. So that's what that language is trying to accomplish, and we think it does a better job than what you currently have in the bill. Finally, Mr. Chairman, we have an amendment on page 11, line 3, and that is to clean up that local approving authority definition. Right now, it only talks about approval, denial, or renewal. It doesn't talk about revocation. So you'll see we add in revoke to that definition. And then we add site specific. It was of interest to at least one of the operators that we be more clear that we're talking about site specific application. So if you had an issue with one location that they had, it wouldn't necessarily unwind other locations that they had within the community. So those are collaborative agreements that we have to bring forward to you. I do want to go back to right of appeal because it is an important issue for my members, and I've made that clear within the working group. I am really fearful relative to right of appeal. And again, this is on initial application that given court decisions that we have, that if we cannot say no on initial application, we're sort of forced to, once we've said yes once, we're forced to say yes to all future operators that come in. Which means for those places like Laramie County, we're going to be in a situation where we're going to have to continue to allow more operators as they come forward. Now, the language does protect at least the 3 counties that don't have operations right now. Those are Platte, Weston, and Teton County. But if the bill stays as it is, I'm probably going to be left with making a recommendation to those commissioners that if you don't want more than one operation in your community, don't ever say yes, because this bill says so. So I have presented a couple of different options, and we have a split amongst the operators of which one is the most useful to them. One of those is to give a 5-year period in which the existing language here stays in place, and then it would automatically repeal. Another option is you give us more power on the front end to say no. And in the event that we do say no, then you would have full right of appeal. But again, we have a disagreement amongst the operators, but I come to you to say that is still an important issue for my members. With that, Mr. Chairman, I'd be happy to answer any questions.
Any questions, committee? Senator Cole?
Yeah, just probably more of a statement, working with the WCCA and the community, local jurisdictions. This is evolving. So we had agreement during the summer that this was going to be the language. And I think a little bit over time, people had a chance to review this and come up with these issues that have come up. Once again, this is a highly complex issue that we're trying to solve while we're doing it. And so this is, I am hesitant sometimes of putting too many amendments on things because I think you just, it makes it more difficult sometimes. You know, we focus on the main one. So I think at this point, I would ask you between the 2 entities, which ones must you have on here in your opinion are the most important? Or maybe it's all.
Mr. Riemann?
Yep. Mr. Chairman, I'm very cognizant of your concern. I do want to push back on the notion that we had agreement on all the provisions that are in here. There were some things added at the end that didn't necessarily sit with my members. But that said, understanding the desire not to have a whole lot of amendments to make this an easy process as you moved forward, we tried to approach it to say, where are the consensus agreements amongst the operators? And that's what I've tried to provide to you. The one that I'm bringing to you that's outside those bounds is the right of appeal. And I've made that very clear throughout this process is an important issue for my members. I'm certainly happy to rank these out if you'd like, but these are things that we have consensus around.
Senator Craigo?
Thank you, Mr. Chairman. Mr. Freeman, thank you both actually for being here, and thanks for bringing us something that hopefully we hear from the operators here in a few minutes that is an agreement for the most part. And so I have no problems with the amendments that you provided to us, except for the last one, and not in the concept. It's just, as I read it, it's kind of clunky. And I don't know, I mean, I think we can approve it for today, but we might think about working some language that's a little bit cleaner when we get to the floor, because as it reads, it's just site-specific application. Are we talking about a change in site or change in location? Does the site-specific application apply to the renewal, the word renewals, or after that? And so I'm just trying to make sure we don't, by adding that, we're not making it worse or dirtier, so to speak. I just want to make sure it's clean. So everybody, when we're done with this, knows exactly what that language means, because as I read it, I'm not sure I do. But and like I said, I'm happy to move it forward for today, and we can second or third reading, maybe come up with a little bit better language. But thanks for your efforts and appreciate that.
Any response, Mr. Raymond?
Yeah, Mr. Chairman, I think you might hear from one of the operators on that particular provision. I'm perfectly fine to other approaches. We frankly discussed half a dozen or more trying to get to it, and we tried to find one place where it fit, and this was the best we've come up with so far.
Thank you for not bringing half a dozen versions of each amendment to us. Appreciate that. Thank you both. Senator Case, are you here for Senate File 58? We actually already cranked that one out. Well, I didn't realize I just now saw you.
Sorry about that.
Yes, just flew right through.
Perfect. Thanks.
Yep.
Thank you, guys.
I thought you were just here to enjoy Judiciary. You did your time already. Okay. Thank you, Senator Case. All right, we'll just open this up to public comment, I think, at this point in time. So if you'd like to comment on the bill, you're welcome to comment on, obviously, the amendments as well that we have discussed so far. Whatever you think is helpful for us to know.
Good afternoon, committee, chairman. I'm Shane Schultz with Brownstein Law Firm on behalf of Cowboy Racing, and I do want to point out that my colleague Avi Ellis did text Senator Case that bill was already heard. He just didn't check his phone. And I want to add it before my colleague starts her comments. We do really appreciate working with the counties and WHAM and the other operators to try and come to agreements where we can come to agreements on those amendments.
Thank you, Mr. Chairman. My name is Afi Ellis, and along with Shane, I am an attorney with the law firm of Brownstein, Hyatt, Farber, Schreck, here representing Cowboy Racing. I know that both of you or two of the members of the committee are very familiar with this issue, so I did have some written remarks, but it was really intended to get all the other committee members up to speed and to make an official record of our position. So bear with me. I know some of this may be redundant for you. For those of you who are not aware, Thunder Plains is the first racetrack to be built in Wyoming in decades, and the first full-size racing track to be built in the United States since 2007. This is a big deal. To put this in perspective, there are currently 2 leased tracks in Wyoming, one in Sweetwater County and one in Campbell County. Each of those are 5/8 of a mile. And there's one privately owned track currently in Evanston that is 7/8 of a mile. Thunder Plains is a full mile. It's located 10 miles east of Cheyenne, just off of Interstate 80. Cowboy Racing is committed to the safety of both the equine athletes and the jockeys. To date, they have made a significant private investment to the tune of at least $7 million or more to construct this track. This is a tremendous opportunity to support live horse racing and the agricultural community in Southeast Wyoming. As you know, operating a live horse track is very expensive. To help provide a revenue stream for live horse racing, years ago, the legislature authorized the use of historic horse racing machines, or HHR. HHR machines look like slot machines, but the outcome of the game is actually determined by the outcome of a historic horse race. These machines, as we have seen, provide critical revenue streams to support live horse racing. Under current gaming commission rules, an operator must offer 16 race days a calendar year in order to apply for a simulcasting permit, which allows for an off-track betting or OTB facility where they can then utilize historic horse racing terminals. Cowboy Racing first approached the Laramie County Commission in October of 2023 about its plans to construct a racetrack. Cowboy Racing has gone back and forth between the State Gaming Commission and the Laramie County County Commission, to receive all of its necessary approvals. In total, Cowboy Racing has requested approval to operate fewer than 300 HHR terminals at 3 locations, and all of those would be located in Cheyenne. Cowboy Racing has received approval from the Gaming Commission and is excited to have race days scheduled for 2026. However, looking back and to give you a little more history, in the midst of receiving all these approvals, Cowboy Racing became very concerned about last year's effort during the legislative session regarding the local control bill. Specifically, there were 2 issues in the bill that Cowboy Racing simply couldn't support. We have really appreciated, as Shane said, the extra year to work with the newly created Select Committee on Gaming, of which both Senator Kolb and Crago serve. And we appreciate the work with the other operators, Wyoming County Commissioners Association and the Wyoming Association of Municipalities. So I know you've went over the bill, but there are a significant number of changes that are being made in this bill, and I don't want those to get lost. First, we want to make it clear that we support Senate File 45 for allowing cities and towns, and not just county commissions, to have site-specific approval for those facilities located within their jurisdictions. Second, we support local control to impose reasonable conditions, such as hours of operation, and that clarifying language is found in the bill. Third, we understand the counties and municipalities' desires to be able to deny or revoke an approval, and this bill provides better guidance on when that would be appropriate, and those reasons begin on page 8 of the bill. Since the legislature first authorized historic horse racing machines in 2013, we have been aware of 2 cases where having clarity in the statute about when denial or revoking an approval would have been helpful. The first case involved the Sweetwater County Commissioner's denial of a Wyoming Downs request to open a facility in Rock Springs in 2014. In that case, the district court found that the commissioner's denial was impermissibly based on economic protectionism, and thus it was arbitrary and capricious, an abuse of discretion, and it violated Wyoming's Equal Protection Clause. This is a significant case. Judge Couts, who, as you know, later served on the Wyoming Supreme Court and is now serving as our Attorney General, he authored the decision, and he cited a number of cases that talked about the importance of treating operators fairly, and that governmental decisions that create a monopoly are contrary to free market economic principles and cannot be sustained. The second case involved Campbell County's revocation of an approval of Wyoming Downs and Wyoming Horse Racing's gaming facilities. In that matter, the Wyoming Supreme Court held that the commissioners lacked statutory authority to revoke any of these approvals. This case was also significant. In the briefing that was provided by Wyoming Downs and Wyoming Horse Racing in that case, they talked about their reliance on the county approvals and their investment of millions of dollars in their facilities, their employees, and in other matters to get their operations going. The Wyoming Supreme Court ultimately held that the counties lacked statutory authority to revoke their approvals. At the heart of both these cases are issues that we grappled with during this interim, specifically issues related to due process and the 100-mile rule. I'll address each of those in turn. On due process, I'll direct your attention to page 9, paragraph J, beginning on line 18. The bill would allow a new applicant to appeal an adverse decision to the district court in the county where the application was filed, with some limitations and conditions that were already discussed. I want to reiterate the importance of due process. Due process is a fundamental guarantee under our U.S. Constitution and the Wyoming Constitution to ensure that governments act fairly and provide notice and a hearing before depriving individuals of life, liberty, or in this case, property. We had serious concerns about last year's versions of the bill because it would have allowed a right of appeal for existing applicants seeking a renewal or a transfer of their location, but it would have denied the right of appeal for new applicants. Why does this matter? Well, Cowboy Racing, as I said, has applied for fewer than 300 gaming terminals in 3 locations, and they're all within Cheyenne. By contrast, our competitors have been approved to operate literally thousands of machines at dozens of locations statewide. So I've provided you with a map to give you a sense of what the lay of the land looks like in Wyoming. I made this map about a year ago, so some things have changed. I think some of the facilities have maybe moved or some have closed. So it's not 100% accurate, but it gives you a sense of what Wyoming looks like. We are very concerned that a county commission or a city council, maybe they feel like there are too many gaming facilities in their community. The easy answer, if they wanted to control the growth, would be to say no to the newcomer, which in our case would be Cowboy Racing, because they could deny our approvals and we'd have no right of appeal. However, these same county commissions and city councils would be less likely to deny a request for a transfer of a location or to increase the number of machines at an existing location, because those would be subject to judicial review if the local entity denied their approval. So I've provided you also with a handout that shows with a little more specificity the number of games that are currently operating in Wyoming and where they're located. And it's a sheet that looks like this. I pulled this chart. It was provided by the Wyoming Gaming Commission, and it was included in the Select Committee on Gaming meeting materials from their June 2025 meeting. I tried to include some handwritten notes about the most updated numbers that were submitted to the Management Council in November of 2025 based on October 2025 numbers. And so you'll see that Wyoming Downs at the time had been approved for 2,310 machines, and they had 1,046 terminals in operation. Flipping the page, Wyoming Horse Racing had been approved for 3,004 total terminals and had 1,032 in operation. Finally, 307 Horse Racing, 1,369 for the total number of approvals and 1,043. So if you add all of those numbers up statewide, and this is excluding Cowboy Racing, Wyoming has approved 6,683 HHR machines for operation. Oh, and currently at the time of these numbers being presented, 3,121 were in operation. So when you think about that, with Cowboy Racing, we've literally asked for 1/10 the number of the machines as our competitors. And so if a county or a municipality is concerned about the growth, we've been concerned about due process because we believe that the solution isn't to merely cut off the newcomer to the game by denying them due process. So I wanted to provide that information for you. So creating any distinction of two classes of operators, those who receive due process and those who don't, really, in our opinion, runs afoul of procedural fairness by punishing the newcomer who has only been approved at these 3 locations. We understand there's concern about the rapid growth of gaming in Wyoming, but please don't shut us out and create a duopoly. And I say duopoly because currently Wyoming Downs and 307 have entered into a joint venture and so share a lot of their management functions. So we are concerned about the creation of duopoly. While we would prefer to have broad due process protections, we have worked with Senator Crago to understand his concerns, and we feel the compromise provided for on page 9, paragraph J is appropriate because it treats all the operators fairly. Accordingly, we strongly urge the committee to keep this language intact. The second issue is the inclusion of the 100-mile rule in the bill, which can be found on page 4, beginning on line 12. This language, as has been stated, is currently found in existing law. Well, for Senator Olson's benefit, what is the 100-mile rule? The concept is simple. The 100-mile rule supports the purses at the local track. Several other states have similar versions of the 100-mile rule, Kentucky, California, and New York, to name a few, and none have been repealed. During race days and race times, anyone operating within 100 miles of the track has 2 options. They can either turn off their OTB machines or they can negotiate an agreement with the live track operator to obtain a waiver, which would allow them to continue to operate their OTBs during race times. Cowboy Racing has maintained the position that it's in the interest of Cowboy Racing to negotiate an agreement with these other operators that would allow them to stay open. And we think this would be a win-win. It would allow them to keep their facilities open, which generates tax revenue for local governments, and it would support the live horse racing event. We believe this was the legislature's intent in authorizing HHR machines in 2013. And in addition, the 100-mile rule was an important consideration in 2021 when 307 Horse Racing, that's the operator that's in Campbell County, when they first decided to lease their track. There is extensive testimony from 307 Horse Racing on the importance of the 100-mile rule. In 2021, the legislature considered a bill to repeal the 100-mile rule, and it was defeated in the House, and it did not reach the Senate for consideration. In full disclosure, since that time, 307 has entered, as I've said, into a joint venture with Wyoming Downs, and their representatives have now testified in support of the repeal. Nevertheless, despite their change in position, the history shows us that the 100-mile rule worked as an incentive to bring horse racing to Campbell County in 2021. Similarly, Cowboy Racing, in deciding whether or not to build a track, it studied the 100-mile rule, it understood the incentive it provided, and they made a significant business decision to the tune of millions of dollars of private investment into the state of Wyoming in reliance on that rule. The other operators have argued that the rule is antiquated, and we disagree respectfully. Cowboy Racing is trying to raise the bar for horse racing, and the 100-mile rule, in our opinion, will help us do that. Further, it's important to keep in mind that the other operators have enjoyed the benefit of entering the market years ago with the 100-mile rule in place. So we've had discussions about the 100-mile rule during this last interim, and we could debate the merits of it at length. But to be brief, we want to impress on this committee something that we talk about all the time in the legislature, and that is business certainty. While some may disagree with the purpose of a 100-mile rule, whether or not it's worked or whether or not it's ever been properly implemented, all of that is beside the point. Keeping the 100-mile rule in place is about business certainty. If the legislature decides it wants to repeal it, it should bifurcate this issue and debate it in a standalone bill. It should not be included in a bill that has to deal with local control. So to be clear, Cowboy Racing supports Senate File 45, so long as it includes the 100-mile rule found on page 4, lines 12 through 18. That is the conclusion of my written remarks, but I also wanted to address some of the amendments that were proposed. And I appreciate the desire to keep a clean bill. But as you read the statute or the bill as it's been introduced, I think there are some things that need to be changed, and we view them very much as cleanup items. For example, the definition of the local approving authority. You don't want to say that they have the only ability to approve or deny, but don't have that language match up on the other side when we've talked about revocations and other things. So I'm happy to address any of those that are of particular concern, but I'd say that a lot of these issues were flagged and raised, and I think would improve the bill. And that, at the end of the day, I think is why we're here, is to try and make the best legislation possible. So with that, I'm happy to answer and address any of the specific questions about our testimony or about the amendments.
Great. Any questions for Ms. Ellis? Yes, Senator Kolb.
Yeah, thank you, Mr. Chairman. Well, the bill in front of us does have the 100-mile rule in it, so I don't quite understand why we're talking about it. It's in there, so I don't know what the need is. I'm confused about that. Secondly, the track, the Cowboy Racing's track, where is it? You don't have a functional track yet. You don't have horses running on it yet. What's the timeline, the projection of when this is going to be actually a workable track that can actually do what you're trying to do? Because it's been going on for years, and I guess I'd like everyone to know just where you're at, because we're talking like there's a track that works, that's running horses on it, and there is no track that's running horses on it. So just where are we at, Ms. Ellis? Could you give us an update on what progress has been made, where we're at, when the anticipated date is for racing horses?
Ms. Ellis?
Thank you, Chairman Olson. Thank you, Senator Kolb. First, I want to say thank you to Senator Crago. During the interim, we invited all members of the Select Committee on Gaming to come and look at the track. I would respectfully disagree that we don't have a track. I believe that my client has, I don't know the exact number, but has spent millions of dollars. The last number I heard was 7 million to make sure that that track is completely level, it's the right oval size. Senator Crago has had conversations with the owner of the track about the top material that will be put on it, rails that have been installed from other facilities to make sure that they're safe. And so we are scheduled to begin racing this fall. I believe the first race dates might start in October, and I apologize, I don't have those race dates, but they have been approved by the Wyoming Gaming Commission.
But to answer your question, Mr. Chairman, Senator Kolb, I think the issue initially this summer was getting power to the track. It was an issue from the power provider of not being able to get them power into. That was one of the hangups, and I think there's been some other hangups that come with it. But I know that was one of the most immediate issues that was a challenge for them.
Senator Kolb?
Yeah, thank you, Mr. Chairman. To be clear, I'm talking about a working track. I'm not talking about part of a track, pieces of a track. I meant a working track that horses can actually race on. That was my intent. I didn't mean there was no half-constructed track. I just meant it's not a working track. So there was a concern about just where some of those race officials would be, if those structures would be completed, so they could actually have a working track. So I meant something that's been approved, power, whatever be the case, and where we're at. I just don't like the inference that there's some sort of track that works out there. My point is there isn't any. These other operators actually have tracks that horses run on right now. I know you're working on it. I'm not taking away from the fact you're working on the track, merely saying that when there's a completion, so there's no misnomer out there about this track that could race horses right now, because there isn't. There's a construction project in place that you're working on, and I'd just like to know when it was, and if you're going to complete it by the race days, then that's the answer. So,
Mr. Chairman.
Ms. Ellis?
Mr. Chairman, they've been approved for race days to begin this fall, and they've been working closely with the Gaming Commission. As you know, the Gaming Commission requires regular updates and status updates on that track. Cowboy Racing attends those meetings, provides those updates to the Gaming Commission. I believe their next meeting is coming up, and you'll get a full update from Cowboy Racing, the people who are on the ground. With all due respect, our role is to talk about some of the policy here. So I don't want to misspeak or misrepresent because I'm not out of the track every day. I'm here representing their concerns about the legislation before us.
Senator Craigo.
Thank you, Mr. Chairman. And this could be to either of you. But do you agree with the county commissioners and WAM on the proposed amendments that are sitting before us? Because I guess I'm not sure we actually heard that specifically as to the ones that were presented to us on the sheet.
Thank you. Thank you, Mr. Chairman. Yes, and that's why I wanted to make a record of this because we have two members who aren't aware of the 100-mile rule. And as the county commissioners and WAM testified, we couldn't get there. So the 100-mile rule is in the bill, and we want to be very clear on our position of why we support the bill in its current form. If the 100-mile rule goes away, we can't support the bill any longer. So we wanted to make that position very clear. And I apologize to Senator Kolb. I know he's heard this before, but our hope was that we would have had a full body of senators sitting before us to educate them on these issues. Specifically, I think that there were some issues where there wasn't a meeting of the minds. When we talked about the transferring of the locations, for example, we asked the county commissioners and WAM, so was your intention that if a facility was located in the city of Cheyenne and they wanted to transfer it to someplace in Albany County, should that be treated as a renewal? And I think their answer was no. But the language that was in the bill right now seems to treat it as a renewal. And so we really were trying to tease out and flag those issues and work on some amendments that would make this clearer and a better product. And so all of the amendments that are listed before you are things that we think improve on the bill.
That's helpful. Thank you. Other questions, committee? All right. Thank you. Other public testimony. Welcome.
Good afternoon, Mr. Chairman and committee members. My name is Kyle Ridgway. I'm the president of Wyoming Downs and 307 Horse Racing. Thank you for everybody's work over a number of years. We started working with the County Commissioners Association probably 4 years ago at this point. On some version of this bill on the 307 horse racing side, based on the testimony that you kind of got about the history of some of the different cases and litigation that came up. One of the things that we faced at 307 horse racing in interfacing with our partners in the counties and the local governments is, we have all these different custom resolutions that have different pieces of language in them. Some counties, when they saw the Supreme Court case from Campbell County, counties thought it would be worth at the outset when we were a new permittee negotiating something contractually. And so as Mr. Ryman explained, the counties don't have great visibility on how enforceable those resolutions are, but neither do we as the counterparty to those agreements. And if courts were to say that those were enforceable, then each operator out of the three that currently have simulcasting operations permitted by the Wyoming Gaming Commission face different restrictions in different counties, and the rules are kind of all over the place if these existing resolutions are in fact enforceable. So from a due process perspective, for those of us that have functioning off-track betting operations in Wyoming, we need this bill for clarity and for our own due process about what it looks like if we did want to have new locations, if there was a revocation on some of our existing permits that have revocation reservations from the counties from inception. So that's one of the reasons that this bill has been being worked for a long time. It was worked by Joint Appropriations before it was worked by the Select Gaming Committee back in 2024. So that narrative is important. As far as where we sit, Wyoming Downs and 307 Horse Racing, we've never taken a position with this bill that we have to have any particular item in it or out of it to support it, or to say if we don't have this, we're not supporting the bill. So I'll just walk through some of the amendments that the WCCA talked about here. to just clearly state where we sit on these different amendments that are in front of you. Issue number 1 was related to the language around off the permitted premises. We're fine with that language, but I wanted to make a point that when you have the words off the permitted premise, there is potentially a hole in this bill that does not give the localities say for simulcasting operations at a track. So at Wyoming Downs, which is our private track, we could put 1,500 machines if we wanted to and would not have to talk to our local regulatory bodies as this bill currently sits. I think that's actually what the law currently says. This was something that we identified. So I just wanted to make that record as we're trying to fix this, because we want to be, this is a regulated industry. We've worked hard as a business investing, well over $100 million between the different entities in OTBs and the track and everything else to make sure that we're good partners. And we're doing right by Wyoming. We've closed a number of facilities in the last couple of years that aren't performing as being good stewards. So I just wanted to make that record. If there's something that needs to be addressed, we may want to add some clarity about what you can actually do at the track, and the locals say at the track. On the 100-mile rule, we haven't changed our position. I've testified extensively over the last few years about our history at 307 and why we changed position on the 100-mile rule after we worked through its workability. For purposes of this bill, our position hasn't changed from what I said at the end of the Select Gaming Committee meeting. You can put it in, you can take it out. It does not matter to us. The third, so that was issue number 2 on the 100-mile rule. We have agreement with the bill as it is. It's not any different than it was on Select Gaming Committee. Issue number 3 on the new conditions on renewal, we had agreement on that. Issue number 4 on the vicinity language, we have agreement on that. We don't have any issue with that amendment. And Chairman Olson, your question about the adversely and seriously affected and what does that mean? The reason we copied that language from the liquor statute is because there is case law interpreting what that means. I can't tell you what it says, but one of the things conceptually we worked through years ago on how we deal with revocations for this industry is the best model was the liquor statutes, because there are revocation rights in liquor statutes. And there's case law that interprets the language. So rather than trying to come up with something new, we already have something we can use there. So that's the reason we had the language. I can't tell you what those cases say off the top of my head, but I know there are cases interpreting that language. On the judicial stays issue, we had agreement on that. On the right of appeal, we didn't really have material positions on how we thought that should look. What I will say is, based on Senator Kolb's explanation about what the localities face, I will say, based on my personal experience going through these permitting processes, that it is hard if a county thinks, you want to be able to successfully get our arms around this industry. It should be clear somewhere at some level, whether that's the local level or the gaming commission level, that if somebody's told no, that they're clearly allowed to do that, how they're allowed to do that, and how the court should interpret the contours of whether they're told no or not. Because the reality of what you face is you have 3 entities who have been in this business for a long period of time, and you have another entity who is trying to get into the industry. And so those 2 groups are going to have different perspectives on how this works, mostly because of the timing of where the investments were made in the industry. And as policymakers, you just have to try to weigh and balance how that works. I think there's lots of choices that could be made about the right of appeal. We don't have a specific opinion on it. We think the way the bill came out of the select committee was fine. On change of location, we had agreement on those issues. On the deny or revoke language, putting aside Senator Crago's points about the language being clunky, we didn't have any issue with those amendments. So, you know, what the WCCA and WHAM put together, we didn't have any issues with. We also thought the bill was fine coming out of the select committee. Let me just check my notes. So we're in support of this. We think it's important for clarity going forward. We think this is a good step for the industry and for the state to get its arms around the contours of when people can be told yes, when people can be told no, and when a governmental entity can revoke. That's important for those of us that are in the business, as well as for those that are trying to enter the business, to make it clear. So we think this is a really good attempt that doesn't arbitrarily cut the knees off of anybody. And I'm happy to answer any questions about our position or anything else.
Committee, any questions? No? Yes, Senator Cole?
Yeah, thank you, Mr. Chairman. Mr. Ridgway, on the change of location language here, do you have any opinions about that? I guess I didn't really hear where you're at on that. And also that other language change below that on that second page.
Mr. Ridgway?
Chairman Olson, through you. So on the change of location, which is the page 10, lines 5 through 9, we were okay with the amended language proposed. It makes sense that as long as you're within a jurisdiction, you want to move around, that's treated as a renewal. But if you try to go outside of the jurisdiction, then it's a new deal because you're dealing with a new regulated entity. So if you went from Cheyenne into the county, it would not be considered a renewal. Much like the liquor statutes, we took how renewals work for liquor licenses versus how new permits or new issuances work. They're different ways those are treated, right? Once a license is granted versus first application of a license. So we liked that language. And the site specific, which was the last one, page 11, line 3, we didn't have any issue with that language on the amendment.
Great, thank you for clarifying. Senator Colton?
Yeah, thank you, Mr. Chairman. Thank you, Mr. Ridgway, for working with us as a group on crafting language that I think we can all live with, certainly better than we currently have. And I understand you need certainty, and thank you for your cooperation and input.
Thank you.
All right, thank you. Additional public testimony. I will tell you, I'm only going to spend about 10 more minutes on this topic. I think if you could just let us know if you don't have to go through all the amendments one by one. If you support them, just let us know.
Thank you, Mr. Chairman. Lori Erbekite with the Wyoming Horse Racing LLC. We support the bill. We will always oppose the 100-mile rule, but we can have that debate another day on another bill, and that's fine. As far as the rest of the amendments with the county commissioners, the only one that I really want to call your attention to is on the appeals, the right of appeal. We have always taken the position if a city or a municipality does not want us there, we will not push it. And so we have no problem with the not having a right of appeal on an initial application. But on the county commissioners' recommendations or suggestions, we would support option A. We think that is a fair compromise. And we also support the rest of their amendments.
So sorry, Lori, can you clarify what is option A? I don't have options.
Oh, I'm sorry. Under issue 6, that is the one that would repeal that entire paragraph as of effective July 1, 2031.
Our copy just says no current proposal.
On issues right of appeal?
On issue number 6, right of appeal, yeah.
Oh, I apologize. I had other language from the county commissioners. I'm
Do
sorry.
you want us to consider something or?
I'm going to let the county commissioners, that's their language, and I apologize. I thought you had it
Okay.
already.
Sounds good. Any questions, committee?
Thank you.
Thank you. Any other public testimony? I know we have one online. Welcome, Mr. Rennie. If you could be brief, we are running a little short on time. We know that you're in support of this legislation, but if there's something that that hasn't been covered that you want us to know, go ahead and let us know.
No, Mr. Chairman, Dr. Rennie, Dr. Mark Rennie, Cheyenne City Council. And I just want to echo what many people have already said. We have worked on this bill for a long time, and we're very happy with the proposed changes and would hope that the committee would consider them. So thank you.
Any questions for Mr. Rennie? All right, that was brief. Really do appreciate that. Thank you.
You're
And now that I'm closing public testimony, the committee has returned. Welcome, Senator Crum and Senator Hicks, to Judiciary.
Well, thank you, Mr. Chairman. I appreciate that warm welcome that you extended to the delegate members.
Always good to have you. All right, with that, I will close public testimony. Committee, what is your pleasure on Senate File 45?
Move the bill.
It has been moved by Senator Kolb and seconded by Senator Crago. Amendments to this bill. Senator Crago.
Mr. Chairman, if it's in order, I'd just move all of the amendments proposed by and agreed to by all of the stakeholders we've heard from today as one amendment.
Second.
So just so that's clear for staff, we're dealing with the handout from the County Commissioners Association. It has been moved by Senator Crago and seconded by Senator Hicks. Any discussion on this amendment?
Just clarification, Mr. Chairman.
Yes, Senator Kolb.
How far does it go? Are we including page 2 on this?
Senator Crago, yes, that's correct.
Yes, Mr. Chairman.
Thank you for the clarification.
All right, any other discussion on this amendment? All right, all those in favor signify by saying aye.
Aye.
Any opposed? That amendment has been adopted. I take it, Senator Crago, you're gonna work on that last one, the language on that?
Mr. Chairman, I will work with the stakeholders and we'll try to clean that up at some point. Probably won't have it ready for committee of the whole, but second or third reading, we'll get something. I'll work with everybody. I think we just need to rearrange the language a little bit. I don't think we're changing the intent whatsoever.
Great, thank you. Yeah, other amendments, Senator Kolb?
Well, I think, thank you, Chairman. I think that basically takes care of it. I'd like to keep this as clean as possible. I realize we live in an imperfect world. I am aware that it's too much, might not make it better. So for my purposes, I think I'm all right with the proposed agreement that we have between the different stakeholders and in totality. And I think I would be all right with that, but I'm just one person in this committee, Mr. Chairman.
I would like Senator Kolb, your opinion, and Senator Crago, your opinion on page 13, line 15. There was a discussion about the June 30th, 2027.
Yeah.
And whether that should be moved to December 31st. This was proposed by the commission. Senator Kolb?
Yeah, I think we should adopt those. I'm sorry, I missed that. Yeah, on page 13, line 15. Strike June 30th and move that to December 31st of 2027.
Okay, it's been moved by Senator Kolb and seconded by Senator Crago. Any discussion on this amendment? And all those in favor signify by saying aye.
Aye.
Any
Aye.
opposed? Amendment has been adopted, and there's a second one on page eight.
8 line.
Yeah, go ahead, Senator Kolb.
Yeah, it's page 8, line 18. In strike after has been found of and then it continues violation.
Do you
Is
mind
that
if I
correct?
rephrase that, Mr. Chairman?
Go ahead, Senator Crago.
Yeah, so let's strike the word acted and add the words been found.
Yes. So that's moved by Senator Kolb.
That's the motion I meant to make.
That's
Mr.
what he
Chairman.
meant to
That's what I
say.
meant.
Good job. Seconded by Senator Crago. Pierre, got that? Any discussion on this amendment? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment has been adopted, and that's all that I have. Any other amendments or discussion on this bill?
Just
Senator Kolb?
just to make a statement, thank you to everybody that spent time on both sides of this issue to get us where we're at. I think we can still work on this and bring it forward, and it's not finished yet. So I think working with, obviously in this case, Senator Crago, we need to do that. but I want to thank everybody. I think the general public probably has no idea how much time was spent on this and how many, literally, probably years this has been going on. So this is a big step forward. Big thank you to everybody.
Senator Crago.
Yeah, Mr. Chairman, I just wanted to acknowledge, I know the counties in WAM probably have want to have a continued conversation on the right to appeal. We didn't probably settle that issue today. I don't know if I necessarily agree with their position, but I know other people will. And so we need to, I just want to bring that up, that will, I'm guessing as we move through the process and get to the floor on all three readings, that may come up for discussion, just pointing that out so that we're not ignoring their requests here today.
Thank you, Senator Crago. And I will say, I appreciate everyone, the associations and the stakeholders all working together on the legislation and the amendment. When this bill was re-referred to my committee, I was like, oh no. And then when I heard there were amendments, I was even less thrilled. So the fact that you came in with amendments that everybody had agreement on, I really appreciate that. It made it a lot easier for me, as this is really my first exposure to the legislation. So I do appreciate everyone.
So, Mr. Chairman.
Senator Hicks.
I just want to establish for the record, that's not the reason I was a little bit late getting here.
Well, so established. All right. Anything else, committee? All right, Pierre, will you please do a roll call vote on Senate File 45 as amended?
Senator Crago,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Aye.
Senator Cole,
Aye.
Chairman Olson,
Aye.
5 ayes.
All right, thank you. And I assume this will just go back to you, Senator Cole, or Senator Crago?
I'll start flooring it, and with the backup from Senator Crago, I'm sure I'll floor it, and then with backup from my colleagues, I think we'll do fine.
Sounds good. All right, we've got one last piece of legislation. Senator Larson. This is Senate File 67, Wyoming State Guard amendments. Welcome, Senator Larson.
Thank you, Mr. Chairman. Senator Dan Larson here with Senate File 67. I know we don't have much time. We got to get up stairs to present the budget. It's a pretty short bill. I've had it to the legislature, I think 3 years now. It's pretty easy to explain. There's two separate portions in statutes referring to our military. There's the National Guard statutes, Title IX, and then there's State Guard statutes that we're referring to here in Title 10. And I want to be clear that they're separate. There's no funds that would come from the National Guard into this, and there's no effect on the National Guard. So this bill would give the governor the ability to organize and maintain the Wyoming State Guard like it states in the statute already, but it takes the federal government references out of here. Before, I think it was 1983, I think the federal government was involved. You kind of had to have the National Guard ordered into service and actually out of the state before the State Guard could be established. That's changed. The federal government doesn't want anything to do with it. There for a while, it needed permission from the Secretary of State at the federal level. And so we deleted that part. We inserted, I'm just kind of in the bill, hopefully on page 2, inserted some new language on that the governor deems necessary on line 10 to preserve the public peace, to execute the laws of the state, to suppress insurrection and to repel invasion. That kind of flags everybody. Those are actual words out of our Constitution. So the LSO pulled them out of there and put them in there. So I think they're good to have there. If you go a little further, it states that the rules and regulations will mirror the National Guard in governance and such. I did want to mention here in a bit, I'll get to that, I guess. And then on page 3, we'll go down to pay and allowance. The intent is not to pay any unless they're called into duty. If we got that far, it would take legislative appropriations from the general fund to fund that, or the governor would use his public welfare emergencies statute if that ever got to that point. On page 4, they refer to getting equipment from the Department of Defense. That was deleted. We got on to page 4, line 17. We had some changes in the age. We changed it from 17 to 25 is the where you could be, and the 65 as the eldest person. So we changed from 17 to 70 to 25 to 65. The thoughts are there is if we did do this and we were looking for volunteers, we wanted some that were trained and they don't want old people like us. But the whole idea was to raise it to 25, and hopefully they had military experience and such like that. So there wouldn't be that much training. There is discussion about an appropriation for $25,000, and that was to set up the Council of Defense. That is already in statute. In the State Guard statutes. And I don't think it states the number or anything. That would be at the discretion of the governor to set that up. But if we did get it set up, we needed some funds to have meetings and pay them, to go discuss how we might set it up. I think that's the whole idea. I do want to state that I've been in constant work with Major General Porter and his staff, and I want to thank them for their support in drafting the bill and supporting the need for the amendments to this statute. I think I'm going to leave it at that and see if you have questions.
Senator Craigo.
Thank you, Mr. Chairman. Thank you, Senator, for bringing us the bill. The appropriation of 25,000, I don't know what that's, it says it's going to be used for, to appoint and convene the Council of Defense and establishing and equipping the Wyoming State Guard. 25,000 isn't going to get us very far. So I guess I'd like you to explain how you came up with that number, and if this is just if we're just doing this to say we did it, or are we actually going to do something and give them the things they need to actually do the job?
Senator Larson.
Mr. Chairman, I would, I don't, maybe that needs to be deleted. I think we need to get the Council of Defense set up, and the $25,000 was for that. Maybe I'm not answering.
Senator Craigo.
So what good does it do to set up the Council of Defense if we're not going to give the State Guard the things they need to do the job, if that makes sense? For example, ammunition, firearms, whatever you are contemplating with the enactment of this particular piece of legislation.
Mr. Chairman,
Yes.
I think the whole intent would be to try to get this set up. I'm not sure if we're ready to determine the dollars that are needed. We need to get a Council of Defense set up, see if we have maybe volunteers that might want to join. The intent, I think right now, is to set them up, definitely be volunteers, not so much as having guns and bullets. I think just one of the big things we would like to have is if the National Guard is pulled out, they have lots of duties that they do throughout the state, and they're not shooting guns and stuff. I think it's more of, this could help the National Guard. If they're pulled out, they could sure help in those situations where you have floods or whatever.
Mr. Chairman,
Senator Hicks.
So thank you for this, Representative Larson, or Senator Larson, excuse me. Didn't want to provide a demotion, in your grade and your pay, but Senator, having been in the past, I think, a similar co-sponsor of this thing, I'm just curious as to what problem are we resolving here? So what's the real issue? Is this the fact that the president can call the Wyoming? Is that what we're trying to get to here? What are we solving?
Senator Larson.
Mr. Chairman, I think one of the big issues is if our National Guard was completely called out of the states, we really don't have a backup. And I think we need a backup, maybe for emergencies and such where the National Guard is used. I think that's my intent, and I hope that I might hear the same from Major General here. But that's, and have an organized group of men out there that can be called, and they're actually have some commander out there that, if the governor said, I need some help, let's just say Park County, no National Guard, we got these guys, they're organized. Major General will be overseeing all of this, and it does state in the statutes, and I had them here. Let me make sure I can find those where it references. It would be in part C of. Oh, dang it! I'm sorry, I've lost it. I had it. It'd be 101. Here, I'm sorry, Mr. Chairman. I'll find it. I'll come back.
Okay.
Hopefully that answered some of it.
Yep, when you find it, just let us know.
Here we are, page 3.
So, Mr. Chairman, if I can
Senator Hicks.
extend that question.
Yes.
So when, if, and how, if there was a request by the federal government for guard assistance, so how would could they still go in, or would it be only under the authority of the governor to be called in for service so let's say like we currently do, I think earlier we've realized our guards all over the world right now. So it would only be if approved by the governor?
Senator Larson.
Mr. Chairman, I did find that section. It's 1910-101C, and it actually reads the adjunct general of Wyoming shall be in the control of the Wyoming State Guard, subordinate only to the governor in matters pertaining thereto. So these guys can't just go out on their own. They have to have the commander say so. So hopefully that helps.
A follow-up. So if we have a situation like we've had now where the guard's been called up to at a number of places around, the only way that this could happen now is if another governor for another state asked our governor, because the feds now, they could come and ask, right? So the president of the United States could come and ask the governor and say, could we have your guard? Would it operate now that we don't have to have the federal government involved, that the guard of one state, that the governor of one state could call our governor and say, hey, we want your guard? Could they then be deployed under this? Because now they're under the complete authority of the governor, correct?
Senator Larson.
That would be my understanding, and I'm not sure if in the statutes, and I should have read a little closer, maybe the Major General can help me on that. I'm not sure if the state guard could be called out and go to other states.
Thank you. Major General Porter, you go ahead and you can answer any of the questions that have been asked or tell us what you think that we need to know.
All right. Thank you, Chairman Olson. Appreciate it. For the record, my name is Major General Greg Porter, and I'm the Adjutant General of the state of Wyoming. Thank you for the opportunity to be here in front of you today. At the risk of insulting anybody's intelligence, I just wanted to go back and maybe talk a little bit about the National Guard of the United States, which is what I command as the Adjutant General. Primarily, that is funded by the federal government in a Title 32 status, which means the governor of Wyoming has control authority over the state National Guard, us, on a day-to-day basis. We also have the ability to transition to Title 10 very quickly because we are the primary combat reserve for the Army and the Air Force. So the National Guard of the United States can travel between Title 32 and Title 10 and state active duty. No problem. This state guard is an entirely separate entity which would not be touched by the federal government, nor could it be touched by the federal government at all. So this would be a separate group entirely that would be only under the purview of the governor and subject to his or her authorities as a state guardsman, if that helps. The purpose for this is as we continue over the last 30 years, we have executed the global war on terror, and we have deployed overseas, and we've continued to do that. This next fight that we prepare for, we think is going to be much bigger, and I think that if we go against China, Russia, North Korea, any of those folks that come together, they're going to attack us in the homeland. And my concern, as I started to think about this, is what happens if we go to war and the National Guard of Wyoming has to go with it. We haven't had to do that. In many, many years, many decades, have we emptied the Guard, and it's not something I contemplated until probably 5 or 6 years ago that we would need to think about this. But now I think we need to put some brain sweat into what would we do if, for one, either we get up and leave, or two, they just federalize us and make us all Title 10, of which we lose a lot of authorities in the state of Wyoming. So no longer are we covered by posse comitatus in a Title 10 status. We become just like the active component. So those two things can cause me concern. I'm probably the only individual left in the Guard that would not be called up because I'm the Adjutant General. Everybody else could be changed the authority. So we started to think, well, we need some sort of organization to perform the functions that the National Guard of Wyoming is responsible for. This first part, this 25,000, was really to establish the committee, the Defense Council, get some computers, get meetings scheduled, really to start this, because we're going to have to flesh out what the state National Guard of Wyoming looks like. And there's all kinds of models out there. California, Florida have a tremendous state National Guard. They use them quite often, but they're expensive. Other states have the ability to establish a state National Guard, haven't activated like us. We haven't done that. The authorities are in the statute already, but we haven't stood it up. And then there's some that sort of fall in the middle of that they do some level of state National Guard that for their states. So there's a lot to be written. It's a wicked problem, I think, this establishment of the State Defense Council and starting to have those meetings. We're going to come eventually back to the legislature with some recommendations about what does the state of Wyoming want to do with its state guard, whether it's a minimal, whether it's something, or whether it's the Cadillac. So this is what it starts to provide some resources for us to really establish that and start thinking through the wicked problem that I think it could be if things go bad. Happy to answer any questions, Mr. Chairman.
Thank you, Major General Porter. That's very helpful. Definitely, I think we were going down the wrong track for a little while with that, so I appreciate you getting us back on track. With the.
I appreciate that explanation, but I just want to make crystal
Go ahead.
clear in my mind based on the title. So the way I understand it is we have to have a National Guard to be able to have a state guard. Is that correct or not correct?
Mr. Chairman, Senator Hicks, that is not correct.
Well, the way I read, and maybe correct me, this is where I'm getting off track. It says this removes, so Wyoming State Guard, removing the activation of the National Guard of Wyoming into service of the United States as a prerequisite for the organization of the Wyoming State Guard. So we've got two different entities here, right? But it looks to me like we're going into the National Guard statutes and setting up the State Guard. That's not correct. Okay.
Major General Porter.
Mr. Chairman, Senator Hicks, as I looked at that, one of the things that was the trigger to get the state National Guard going. We don't want to restrict the governor to that trigger that the National Guard would have to leave.
Okay, thank you.
Yep, thank you.
Got a question.
Senator Cole.
Thank you, Mr. Chairman. Well, I'm pretty confused now. I don't hear much of a plan. First question, Adjutant General Porter, is who do you work for? I mean, I assumed, I guess at one point you worked for the federal government under that.
It's appointed by the governor.
Is it appointed by the governor? So it's clearly you don't. So you just administer that here in the state of like the program, the National Guard program you're just in charge of that and use assets. This is the problem I'm confused. You have assets that are owned by the federal government. Isn't that correct?
Major General Porter.
Major General.
Mr. Chairman, Senator Kolb, absolutely. Each state has an adjutant general, and we are the only ones that are 100% federal and 100% state, 100% of the time. We occupy a very interesting position in this. So yes, sir, to that point, I understand. But the governor appointed me, and that is my boss. He is my commander in chief.
Senator Kolb.
Yeah, just follow up. So the next part of this is how will this actually work? So let's just say there's a call out, all the guard leaves, it's some major catastrophe. What do we got? We're I guess training and equipment. You can't give up your equipment and give it to this said group, can you? That was so I want to know the timeline, because it looks like it isn't going to be quick. And so that was my one question. What is your anticipated timeline to get this thing up and going in the case of an emergency?
Yeah.
Major General Porter.
Chairman Olson, Senator Kolb, yes, sir. A wicked problem, as I said. I think there's going to be a lot to talk through on this one. We can't use any federal equipment funds or anything to that extent. So that's why this seed money that gets us starting to talk about what's it going to take? What are we willing as a state to invest in the capabilities that when the Wyoming National Guard leaves, are we comfortable with? I don't have the answer for that yet. I have my own perspective of what I think we need, which is to perform the functions that I'm responsible for right now when the Guard leaves. But there are other folks with different opinions. So I think this starts to coalesce around where do we want to go and what do we want to do and what do we want our state National Guard to be capable of and to be able to do. I don't have the answer for that, sir. I think it's a 2 to 3 year process for us to get to that answer. Porter's opinion, sir.
Mr. Chairman, and I
Yes.
would agree with
Senator
that.
Larson.
The idea was to just pretty much get the council set up, get an idea what we're really wanting with the Major General's influence or opinions for sure. And he would be the main guy for the council. Yeah, I think he might be the chair. I'm not sure if it's said that way, but yes.
Senator Larson, was there any discussion with the military committee about the transportation committee about this bill, or they just didn't take it up, or what?
Mr. Chairman, I'm not sure where we'll go with it, but I've brought it twice and I've just not had success in that
I
committee.
see. Okay. Senator Crago.
Thank you, Mr. Chairman. So a couple of questions, Major General. So one, the statute already provides that the governor shall set up the council. So I don't think we need a bill to do that. I guess the question is, why has that not been done? That's my question number one. Question number two is, if you go to 19.8, Title 19, Chapter 8, we talk about the state militia. Could you teach us, because none of us are on transportation and military affairs.
I am.
Sorry, this guy is. I'm not.
This guy.
I don't
Couldn't have voted.
understand what the interplay is between the state militia and the state guard. Like what are we talking about there? So because there's cross references back and forth between those sets of statutes.
Mr. Chairman.
Yes, please.
Senator Crago. So it does, Wyoming traditionally has not stood up the State Defense Council. Largely, the Adjutant General and Office of Homeland Security sort of fill that role to advise the governor on that one. But we've never done it. And why, I couldn't tell you. There's no resources to stand it up at the particular time. As I said, most of the resources I get is on the federal side, and we can't cross the streams on this one. Sir, would you remind me of your second question? Oh, about the militia. So the militia is talking about the State Guard itself, not the National Guard of the United States. We, as you notice on our uniform, it says U.S. Army or U.S. Air Force. That means we are the State Guard of the United States, even though we're under the command and control of the governor. Most of the time, we can convert. This would not say that. We would say Wyoming National Guard or Wyoming State Militia or Wyoming across it, totally disconnected as the state militia from the National Guard of the United States. Two different entities, if that helps at all.
Yep. So to help you with that, Senator Crago, you are the militia.
Mr. Chairman, follow up?
Yes.
So I see that. I figured that was gonna be the answer. But I just, for example, we're changing the age qualification in 1910, but we're not changing it in 1908. And if they're one and the same, maybe we need to figure out. I mean, I think we're gonna create some issues within the statutes there. We're probably gonna have to look into that a little bit deeper and look and actually analyze the cross references between those two different organizations, or well, two different sets of statutes, because it's one organization.
Major General.
Mr. Chairman, Senator Craig, I think you're right. I think there's going to be a lot of amendments to this as we go through. Some of the stuff that we have here will undoubtedly change as we sort of develop this problem a little bit more.
Mr. Chairman,
Senator Crum.
two questions follow up on Senator Craig's question. Why the change from 18 to 25? I mean, I heard the testimony about, well, we would want a little more experience, but isn't training some young guys to help, or young guys and gals, excuse me, but to help and to grow in leadership beneficial too?
Major General Porter.
Mr. Chairman, Senator Crum, yes, sir. That was the thought process when we were kind of working through this, was they were looking at sort of some more experienced personnel. I am not personally hung up on that. I do think I'm fine keeping the standards the same and let those that are assessing them sort of use a little broader set of circumstances to do that. So I personally am not upset about it, but I recognize what the discussion was, which was trying to make sure we had a little more seasoned individuals in that deal, but not hung up on it, sir.
Senator Crum, go ahead.
Yeah, and I'd see that too. You know, this certainly want seasoned people in leadership and that type of thing. The second half of my question is the following up on the comment that these folks won't have guns, but if the National Guard up and leaves the state and goes to France or wherever we go, do they have guns or don't they have? I mean, do we have protection or not? I guess is the question.
Mr. Chairman, Senator Crum, I think that's to be decided by the people that are going to work this. I think that's going to be one of the courses of action. Not as high on my priority list. I want more folks that maybe cyber defense to help us, sandbags, wildfires, that sort of thing that I'm after. But there are members of the communities that want the ability to repel insurrection and do that sort of thing. So I think that's open for discussion and debate, and we're going to have to decide that as a state on what capabilities do we want to put into the State Guard.
Thank you. Senator Craig, go back to you.
Thank you, Mr. Chairman. I was going to point out to the Major General that I don't think the language in the statute, either currently or as amended, allows for you to address natural emergencies or natural disasters. So we might want to think about adding some language to that effect if that's part of our goal here. Between now and when we get to the end of the journey here, we probably better come up with some language regarding that.
Sure.
Thank you, Mr. Chairman. And thanks, sir. Noted. Yes, sir.
I have a quick question.
Yeah.
Yes,
Senator
real quick. Thank you, Mr. Chairman. The profound question I have is, why do we need this? If the governor can already do this, maybe it's a bad question, but why, if the governor can do it now, why hasn't he done it? Thank you, Mr. Chairman.
Major General Porter.
Mr. Chairman, and I won't speak for the governor. I can tell you from my history, it's because I, as the Adjutant General in the Wyoming National Guard, has largely performed those functions. And the federal equipment that we use to respond to those have largely been available. What we need to think through now is what happens when that doesn't happen. And so without the resources, since we can't cross the streams of federal and state, we have to have a bit of state resources to sort of prime the pump and get us thinking about this, getting us meeting together, have the computers and stuff to do it that doesn't touch the federal side of things. So that's why I would say let's start this, and why the 25,000 that we've talked here is important for us.
All right. Thank you, committee. Thank you, Major General Porter. Thank you, Senator Larson. We'll take any other public comment we have, and then we'll kind of go from there.
Appreciate it, sir. Sorry I was late. I had to testify at another one, so thank you.
You were actually perfectly on time.
Thank you.
Any other public testimony? Online? Bill Tellen. Let's let him in. Okay, well, I will go ahead and close public comment because we do not have a lot of time before we have to be back up to the chamber to hear the presentation of the budget. So I'll close public comment. Committee, what is your pleasure with Senate File
Mr.
6?
Chairman, move the bill.
Senator Hicks. It's been moved by Senator Hicks.
Second it.
Seconded by Senator Craigo. All right. Discussion on this legislation, Senator Crum?
Yeah, thank you, Mr. Chairman. I like the concept, but I think through our testimony and working today, there's just a whole bunch more that needs to go into this before I'm ready to vote on a bill. Because I kind of understand the global picture, but I don't understand where this bill's actually headed and how it all fits into the thing. So I guess that's where I'm at today. I truly like the concept, but I'm not sure where we're headed today.
Yeah, I'm not really, I've got some mixed feelings. I asked about the interim topic. I do wish it had made it onto an interim list. I think there's a lot to flesh out here. It's a very important issue. And I do support the issue. I wish it had been an interim topic that could have been studied. I'm also disappointed that am not hearing from the governor's office. This bill directly impacts the governor's office. And although it also impacts Major General Porter, we heard from you and I appreciate that, but I would have liked to have heard from the governor's office. Senator Larson, I don't know if you have any information about why the governor's office didn't send someone today, or have you been working with them? What do you know?
Mr. Chairman.
Yeah.
Yes, we have worked with them and Major General Porter and we've sat with them before and they've had some representatives when we've discussed the bill. I don't know why they didn't come down to push for it, but I guess I just don't see where he's going to do a whole lot with the Council of Defense until he has an idea that, we're ready to set it up. If we get rid of some language, especially referencing the federal government, I mean, at least get that out of there.
Well, with respect to the council, he would appoint, the chief executive would appoint the council. So he's central to this legislation, right?
I agree. Yeah.
Okay. Committee, anything else? No? All right, we got 2 minutes. Pierre, go ahead and do a roll call vote.
Mr. Chairman, are we going to work the bill?
That's what I'm asking. That's what I was asking.
Oh, yeah.
I said anything else.
No, okay, I didn't.
If you have, you
We're
have
right.
amendments,
Yeah,
Senator
I
Hicks?
just want,
Okay.
to get this thing started and get everything under 1910-102. I think the pay allowances and the age and the requisition of arms, I think that detracts for what the purpose is to get this set up and get the state guard. People are going to get focused and fixated on that. It still leaves the substantive part of getting the state guard set up. All these other details, I think, based on the testimony of the colonel, need to be worked out. And so I'm just trying to narrow the focus of this. And so it's basically delete everything.
Delete 1910-103.
Yeah.
Delete 1910-105.
Yes.
Yep. And then leave section 2.
Leave section 2.
So section 1 also delete 1910-102. Sorry.
Correct.
So it is just, section 1 is just 101.
And the appropriation
And then
the sponsor to try to. get
Section
this
2 is the
focused.
appropriation. Okay, do I have a second on that motion?
Okay.
Seconded by Senator Crum. Any other discussion on this amendment? All those in favor signify by,
Yeah.
Yes, that's correct. Okay, all those in favor signify by saying aye.
Aye.
Any opposed? All right, anything else, Senator Hicks?
Nope.
Anybody have anything else for the good of this bill? All right, yeah, let's,
Just a comment.
oh, you want to
Just real
comment?
quick, just
Okay.
real quick. Until I see the governor's office down here, until I hear from the governor, who's gonna have to implement all this, how could I support it? I mean, even if the concept kind of would work, conceptually, I don't know if we have the time to fiddle with this right now. It's died many times in transportation. That's the reason why you hadn't seen it come out of there. And without the governor being here, which I don't know what that means, except I no information. So I'm concerned about that. I'm very concerned because the governor's the key component. If he vetoes this bill at the end of the day, then what do we have? So that's the reason for my no vote. I just want to explain it.
Anyone else? Any comments on this legislation? All right, Pierre, will you do a roll call vote on Senate File 67?
Roll call on 6567 as amended. Senator Craigo. Senator Crum.
Aye.
Senator Hicks. Senator Cole.
No.
Chairman Olson.
Aye.
4 ayes. 1 no.
There you go, Senator Larson. All right. We'll take up the amendment, Senator Larson. You'll take up the bill. All right, we are adjourned. Yes.